So during COVID, we represented a little girl who in 2020 wore her mask to school that said, Jesus loves me. And she was told that she had to take it off. We represented a boy, and his case went all the way up asking the Supreme Court to take the case because he wore a "there are only two genders" shirt in response to sharing his beliefs about gender when his school was advocating for radical gender ideology. And he was punished at school for wearing that T-shirt. And then in the time period right after, so recently, Charlie Kirk was assassinated. We saw students wanting to paint the rock at school or take other measures to try to honor his legacy and support free speech in his honor. And they were being shut down and punished by schools, in addition to a growing history of school clubs that were being shut down because they were pro-life, religious in nature, TPUSA clubs, while other clubs were able to freely operate on campus and share their viewpoints. So exactly what was shared before about this act was important. We need to make sure that all students can speak their minds. The public schools should be a place for public debate, for students to be able to build their own views about the world and talk about those with their friends and be able to get used to talking about and defending their views.
Hello, moms, dads, and grands. If you're new here, welcome to the School for Parents, Grandparents, and Friends who are committed to defending and preserving liberty with a special focus on topics that impact kids, schools, and of course, parental rights. This summer, Moms for Liberty is unofficially declaring June to be Parental Rights Month. This topic is close to our hearts, obviously, as defending parental rights is part of our mission. Oddly enough, parental rights, which essentially is just the right to raise your kid as your kids, has somehow become a political partisan issue. Seems like everything today is. Quick, who makes the best fries? Burger King, McDonald's, or Wendy's? None. Obviously, it's Chick-fil-A because they make God's chicken, so clearly they have the best fries. But we're not here to talk about fries. This summer, we're going back to the basics, learning just why parental rights are so important to a free society and the history of parental rights in America, at least legally. Today, we're joined by Kate Anderson from Alliance Defending Freedom, who's going to help us unpack some of the major rulings by the Supreme Court to uphold and affirm parental rights. All right, let's get into it. Welcome back to class. And welcome to the program, Kate. We are thrilled to have you here.
Thank you for having me.
Tell us real quick about what you do at ADF.
Yeah, so I am a senior counsel with Alliance Defending Freedom. I'm an attorney here and I run our parental rights team. So a few years back, we saw what was going on in the country, decided we needed a dedicated litigation group to focus in on this issue to protect parents' rights and help them, particularly in the school context. And so that's what we've been doing ever since.
I am so thankful that we have lawyers who are fighting the good fight for us, because it feels like today everything, all of our major battles, not all, clearly not all, but it feels like so many major battles are decided in the courtroom. So let's start with a baseline. Why don't you tell us what do we mean when we talk about parental rights, and why are they so important to a free society?
So parental rights are important because kids are important. And they're the recognition that kids are born into families and that families are the ones, their parents are the ones that are responsible to raise their kids, to direct their upbringing and their education, to help them make decisions before they're old enough to make those decisions themselves. And so parental rights really key off of the core duty of parents to be the ones to raise their kids and walk through difficult life circumstances with their children as they're growing up.
Yeah, we're the ones we're really doing the hard work. Anyone who has kids knows that for sure.
Oh, much.
So why has I think we're very thankful. I am very thankful in America that American legal tradition has actually been very consistent in protecting the family as an institution, which is fantastic. So why is it that schools and government agencies, well, all throughout our history, frankly, have often been the flashpoint in this conversation or in this topic, in this debate?
I think it's just where you see parental rights and the government coming together so clearly when we're talking about how you educate kids, especially in the world of public schools, where you have parents really partnering with schools. And when we talk about parental rights, we talk about the them as being fundamental and pre-political, which means that they are rights that are just innate to us as human and free people. They're not rights that are created by the government or given to us by the government, but they're rights that are protected by the government, the Constitution. And so that's how all of the historic cases have talked about and approached this right. But we see it coming into sort of conflict so often.
That makes so much sense. I mean, after all, that's where kids are so often, or for so much of their, well, weekday childhood, right, is in school. So it does make sense that that would be it. Do you think that's our society? I mean, I feel like this is a loaded question, but do you feel like we're shifting from a perspective that parents are understood to be the default decision makers and leaning towards trusting the state, that the state knows best?
Yes, but I think we're coming back. And I think groups like Moms for Liberty are showing that we're coming back. So I think there has been such an understanding at the founding of our country and for so many years in our history and tradition, both in law and in our culture, that parents are the ones who raise kids. They're in the best position to know who their kids are, to know all the circumstances surrounding their kids. And there is this innate love for your kid that you're going to try to do what's best for them. And so there was a recognition of that. But as the government became sort of more was shifted to the government control, and you see that coming in public schools in particular, as well as other areas of family life, that I think there was more of a willingness to defer to the government, particularly in the school context, as the experts when it comes to children. And so you had that shifting that I think really changed with COVID, when parents saw at their dining room table exactly what the public schools were telling their kids and how they were educating their kids, and they didn't like it, and it didn't coincide with their own beliefs and how they wanted to raise their kids. And so I think we kind of are coming from an era where there was a lot of deference to the government in how to raise kids and how to educate kids. And now we're seeing parents really stand up and say, no, they're my kids, and I'm the one who knows best how to raise them. And the government shouldn't be interfering with my right to do that, especially in light of recent stories coming out about schools that are hiding information from parents and lying to them about their kids. That's just sort of put it right on the nose.
Yeah, that I agree. I mean, I still find it absolutely, it just almost breathtaking when I hear about these schools that think that it's appropriate to lie about the child that's going through such challenging times. We weren't really planning this, and this is purely anecdotal. Just curious. Why do you think? What do you think led us to that point of being so willing to trust the government? Because I felt like that time period was pretty patriotic still. We loved our country. Like, what? How do we get there? And I'm so glad that we're coming out of it, by the way.
Yes. I mean, there's probably a million factors that went into this, but I think we've just seen our government grow in so many areas of our lives that the government is providing more and more in our lives as the country has grown than was really happening at the founding. And that has been so much in the context of public schools. And as you see it become more expensive to private school kids, or there are barriers to being homeschooling, more and more parents were putting their kids into public schools. And the public schools historically have been good, providing great education. But there's been sort of this running to those public schools, I think, by families, and then just a deterioration in the education quality in some of the schools and some of the focus of what those schools are doing with kids that has caused this clash to happen.
Yeah, it definitely didn't happen overnight. That's something that I think, boy, I mean, I joked that a minute ago that it feels like it's been a decade since 2025, but truly, I mean, gosh, does 2020 does not feel like it was just 6 years ago at all. Okay, let's shift over and talk about some of these major cases. That's what I'm really excited to have you here for, is to unpack some of these real core decisions that have rulings from the Supreme Court that have supported, affirmed, validated, strengthened, protected parental rights in America. So let's start with Meyer v. Nebraska. What was the core issue there?
That court case arose because there was a teacher who was teaching German to a 10-year-old. And there was a law in Nebraska at the time, this was post-World War II, that said that students under 8th grade could not receive education in a foreign language. And so That teacher was actually criminally convicted. It went all the way up to the US Supreme Court, which overturned that conviction and said that that law was unconstitutional. And sort of core to that decision from the court was the parental rights element of that, which is why this is one of the first cases that we see cited in parental rights litigation. This was a case that said this parent had the right to go and seek this education for their child and to hire this teacher to provide this German foreign language education. And so it talked in very broad terms at that point, without a lot of sort of undergirding of the tests and the elements and things that we often see in case law, but just sort of marked out this principle that parents are the ones who direct their kids' education and upbringing, and that includes being able to choose things like foreign language education for their young children.
That seems it almost seems laughable, and I don't mean it in that way, but it seems so unusual that there would be a court case about learning in German when we have so many languages nowadays. Is there, I mean, can you very quickly recap why it would have been such an issue to have it be in German versus English?
This was following World War II, and or World War One, rather. This was following World War One. And so it was just this desire for patriotism, for us to have a unique or one language through the entire country. So they were really trying to, I guess, in Nebraska, cap down on other languages and other cultures to bring sort of this unification. I think that was sort of the desire behind it. It clearly was a problem for many parents, including me.
Yeah, I appreciate you putting that context. It's really, really important. I know that we see that a lot with civics and history in general, that we try to we put our culture or our values. We see the history through the lens of modern day values, and it just doesn't apply. It doesn't make sense, and it's so important to take into account the context of the times. So, why exactly is this case still relevant? Why does it matter in disputes over curriculum or language or educational choice? Because it seems, I mean, obviously we're okay with other languages. So why is this one so valuable?
It's because it's the first case that really set down this idea in Supreme Court case law that parents are the ones that direct their kids' education and upbringing. And it's followed very quickly by a case called Pierce versus Society of Sisters, which we'll talk about, I think, in a minute. But this was sort of the first landmark case laying down this principle. And you're coming in a history and tradition at the time that I think this was widely understood by people, that parents raise their kids, not the government. But this was a time when the Supreme Court actually said that. And it's what sort of kicked off a series of cases that then have brought us to where we are today on the parental rights issue when we're talking about the Supreme Court jurisprudence.
Yeah, that makes sense. So then before we talk about Pierce, I want to challenge just a little, not because I disagree with you, but just curious. So I think that it could be argued that there is a certain requirement or legitimate interest, you might say, in the state, in our government, a national government, trying to create a common culture, ensure that we all have a baseline, that our children are educated, to have a single language, ideally. So how do you respond to that?
I think that's very much what drove us to bring about public schools and to make sure that we're getting a baseline education for all kids. But time and time again, those kinds of arguments are made in the case law. And the court time and time again says that that interest can't override the parents' right to educate their kids. And this idea of the duty of parents to be the ones to raise their kids, to educate them, to be responsible for all of those aspects of a child's life, and that's really a decision about who carries the primary responsibility and therefore needs the right to be able to live up to that responsibility. And so it's balancing a little bit of the interests, but saying that when you're finding a clash between parents' rights to educate their kids and the government interest, that in most circumstances the parents' right is going to prevail.
As I think that it generally should. So, all right, that was really good. Let's move over to Pierce v. Society of Sisters. And this, I know, is really considered one of the most important parental rights cases. So can you talk about why that is?
Yeah, this one came about 2 years after Meyer v. Nebraska. So they're kind of companion cases for each other. But this came up, I believe it was Oregon, said that they were going to require every student to go to public school, and you could not choose a religious parochial school or other private schools. And so you have two plaintiffs in that case, a parochial Catholic school as well as a military school, that challenged that law and said parents should have the right to send their kids to our schools. We should be able to educate kids as well when parents choose this type of education. And it's become such a landmark case because it has beautiful language about parental rights and about the nature of the relationship with children that we still quote today. It says that children are not the mere creature of the state, and goes on to talk about what that means, that they're not the mere creature of the state. They belong in families. They're born to families, and families are the ones with the duty to raise them. And therefore, because they're responsible for these things, need to be able to make the best choices for their children. And that includes access to private school and other options. So this is the case that it's 100 years old, and it really is the landmark case that we keep seeing quoted and quoted again in all parental rights cases going forward, because it laid out those broad and fundamental principles. And it set forth in education the idea that parents get to choose between public and private education, which they still do today.
Honestly, it's almost it's almost hard for me to wrap my head around a time that there wasn't the ability to do that. And to think that this ever would have been challenged it makes me realize how much we take for granted so many freedoms that have been won on the battlefield and in the courtroom over the past 250 years. So I think this is interesting, though, because it does touch on or dance around what I think is a very valid concern that people might have, that I could hear as an argument in response, is the concept of educational quality. Because I think that was, for a long time, the issue with homeschool, is this idea that they, weren't socialized children and didn't have good quality, and you're just never know like what they're actually learning. Obviously, that's not the case. Things are clearly a lot different now, but overall it comes back to the concept of educational quality. So what is the difference between regulating educational quality and trying to control the educational institution that families must use?
Well, in homeschooling, as you mentioned, there was a time when homeschooling was entirely banned, and we had to fight through the courts to enable parents the ability to school their parents at home or school their children at home. And I think that those choices are so important because every kid is so unique, and there's going to be different things for different kids that are going to be the right fit. But as to educational quality, we see that all the time in the states, marking out what subjects kids should learn. There's baseline testing that goes on, and accreditation with private school. So there's a way to balance ensuring quality of education while still ensuring parental rights. And at the end of the day, there's a bit of a policy choice being made about whether you trust parents to educate their kids. And the court cases have historically said we have to. We as a free society trust that parents are going to educate their kids, and they're going to fulfill that duty. And absent evidence of that not happening in some significant capacity, the way that we deal with abuse cases, parents are the ones that need to be controlling this piece of a child's life and being able to protect them.
So that makes me think of, and I'm not an expert on the Amish culture in any way, but it makes me think of the very extreme differences. Because I think the next case we're going to talk about in Wisconsin v. Yoder, that was Amish. And I could see the educational quality being a concern, because I think that it's stopped, like general education stops at a certain point sooner than the rest of society, essentially, or our standards in society. That I could really see being a concern. So let's switch over to, because ultimately you want to give parents the choice that they have the right to raise their child as their child. And I can see the real issue with wanting, people thinking they're protecting or helping these kids because they want to make sure that those kids have the same opportunities as everyone else, but then you're telling someone else how to raise their kids. So sorry, I digress. Let's talk about Wisconsin v. Yoder now. Why did the court side with the Amish parents in this case?
This was a case about Amish parents who, in their society, they wanted their kids to do formal education through, I believe it was 8th grade. It was sometime in middle school. And then to be taught at home the things that they would need to be part of the Amish society. And so they wanted to pull their kids out, and the education system at the time said they couldn't do that there was mandatory education laws requiring them to keep their kids in longer. And so there was a case about that that went all the way up to the U.S. Supreme Court. And there I think you do see the court really balancing some of the things we've been talking about, that there is an interest in having this education be more baseline for everybody, for the government to be able to provide a baseline of education while still respecting parents' rights to make their decisions about their kids in the context in which they live, recognizing that we're a pluralistic society and there are families and cultures within our society that are different from each other, and that we want to support that kind of difference and to respect those families' rights. The interesting thing at play in Yoder was that up until now, the court always talked about parental rights, or historically talked about it, parental rights, as being a fundamental right, which is what we talked about at the beginning, and that it's founded in the 14th Amendment of the Constitution. So that meant the Constitution protects it, not because it's written out in the Constitution, like free speech or religious freedom, but because it's sort of recognized as innate to life and liberty and freedom in this country. But what Yoder did was add in the free exercise element and say that this is also an issue of the freedom of religion of these parents and their ability to exercise their faith in how they raise their children and then how they're building their society. And so I think that that's part of what sort of turned that decision, was the idea that this was a parent's choice, but also tied very directly to their religious upbringing for their children and what they desired for that child, and how they were going to educate them partially through the public schools, but then partially through at home at some point in their development.
I don't think it's this case. I think it was a different one that I was reading about that talks about the importance of the courts recognizing the parental authority and deferring to that, even, and not being careful to protect it, even if the court may think that there could be a slightly better position. And when I hear that and the way you explained it just there, it really makes me think of even like a rural versus an urban life. Someone who lives in urban life, for example, and doesn't have to drive because they walk everywhere, but it's loud in the neighborhood and they don't have wide open spaces and they have to walk to get to the park instead of going in their backyard, kind of thing. That to them, that may be an amazing life that they would say, why wouldn't you rural people want this? But someone who lives in a rural community may not want anything to do with that very urban life. And it's really a good reminder of, just because we think something is, we personally, and so I'm saying me, really, not you, but like that there's so many other perspectives in it. And it really is very nuanced. There's a lot of thought to this.
Yeah, I think it also illustrates why parental rights and these issues should be bipartisan, because these are rights that are important for everybody, no matter how they want to raise their kids, no matter where they live or what their culture and religion is. This is about parents being able to make the best decision for their family and their kids. It's not about a judgment on what that decision should be, with limited exceptions, of course. But for the vast majority of parents, this is about letting them raise their family the way that they think is best for their kids.
And I think that's so important. And you've said it before, but truly, we are not in any way saying that there aren't genuinely not good situations that children need to be protected from. But in the vast majority of the time, that's not going to be the case. So that's very important. So Yoder, I've heard, can sometimes be difficult for modern courts to apply. Why would that be?
I think it was for so many years just considered something that was unique to this particular situation. It involved the Amish culture. It was sort of this unique issue revolving around this one particular religious and cultural group. So I think that many people thought Yoder was a little bit of a one-off. It's been sort of revitalized in some recent case law from the US Supreme Court that we'll talk about. But for many years, Yoder was sort of considered this one-off because it looked to free exercise and it dealt with the Amish, and people didn't think that it had much application to other parental rights arguments.
I could see that, especially because I'm not at all implying that the Amish is a cult, but I can say that some people would see those very strict beliefs and very strict values as far to the extreme. And so I could see why someone might see it as more of an outlier as opposed to something that really fits in the mainstream.
It's a situation that's not going to repeat itself over and over in other circumstances that the court's looking at.
Yeah, I agree. I would imagine you're not going to see that too much. Actually, have there been a bunch of cases since that have like addressed Amish religion? No,
not at that level, not going all the way up to the Supreme Court and making this kind of statement that could be precedential like this.
That's interesting. As far as I know, this was the only one, but I do not keep track of Supreme Court cases. I'm not going to lie. So I trust you to do that. No, I'm kidding. All right. So let's talk about Troxel v. Granville now. Why was this one so significant?
Until very, very recently, it was sort of the last Supreme Court case that talked about parental rights and made these sort of broad statements about parental rights being fundamental, that parents have the right to direct the upbringing and education of their kids. And I keep saying that phrase over and over again, but that's the one that's in the case law over and over and over again from the US Supreme Court. And so Troxel was decided in 2000. So we've been talking about how 2020 is a long time ago. Troxel was 2000. And so there was a long space where the high court did not take any parental rights cases. And Troxel was kind of a unique one because it was about a grandparent visitation statute out of Washington state. The core debate was in a divorce situation. I think the father had passed away, but the father's parents wanted visitation time, wanted more visitation time than they were being allotted by the biological mother. And so the court was dealing with, well, how do we interpret the statute? Does the mom get to decide who visits and spend time with her kid? How does this all work? And ultimately, the court came to what I think is the right decision, that the mom gets to make the decisions about the custodial time of her child. And she was giving visitation time to the grandparents, just not as much as they wanted. But it didn't really deal with the core constitutional claim. The court made that decision in a very fractured opinion where I think you had 6 opinions from different justices on the court. And none of them quite agreed about how to get there. They didn't talk in great detail about how to apply the constitutional principles. They decided on some other more statutory grounds. And so what happened was you had this sort of landmark case on parental rights, the one that was standing out there from the US Supreme Court that said parental rights are fundamental, that it's parents that have the right and responsibility to direct their kids' education and upbringing. But then it didn't explain what that meant, what kind of test to put to that, how to deal with that when other issues come up. And so that was all left to the lower courts. And it created really 2+ decades of case law in the courts of appeals and the district courts, where courts were all over the map on how they protected or didn't protect parental rights. And you had a lot of bad cases coming up from the public schools where it created this precedent that schools had wide authority if it was curriculum. Everything became curriculum to the courts. And so parents began really losing their rights at the schoolhouse gate whenever they chose to send their kids to public schools. And while Troxel wasn't directly related to public schools, I think it sort of kicked off what happened there because it failed to give a clear test to the lower courts on how to handle parental rights cases.
Huh. That's a really fascinating point about this. I would not have realized that. I got to be honest, I was just kind of amazed thinking about grandparent. Maybe there's a reason why mom kept the kid away from the grandparents if they actually took her to court, because now I don't know anything about the family at all, but it feels like that's a little bit of an overreach. That said, I agree with you that I think that the courts made the right decision there with my limited knowledge of it. But that is why is it so important to add, what did you call it, to define the test?
Yeah.
Or why is that so important?
It's so important because it tells the lower courts. So we have the US Supreme Court, and then we have courts of appeals below it, and we have the district courts in the federal court system that really are the ones that you usually hear about, that have trials, that deal with issues at the sort of normal level where most people are just in those trial courts. And what happens is the US Supreme Court sets principles to interpret the Constitution, and then typically they provide tests. So they explain to the lower courts, this is how you should look at a free speech case or a free exercise case. This is the factors you're going to look at to determine which way to decide. So when you get new facts, new cases that come to you that are different than the one that's in front of us, you'll know what to do with that and sort of what rubric to judge that case through. And so those tests are incredibly important. And that's been the big hole in parental rights litigation, is that there has been this long history of broad principles that parents are the ones that make these decisions, but no clear test from the highest court in our country to explain how to deal with those rights and how to apply those rights to public school, to healthcare, to custody, to other issues that parents face. And so from 2000s, even into the 90s before that, all the way through until the last 2 years, really, there has just been this confusion in the lower courts where you have some courts protecting parental rights and some courts not protecting parental rights. And this has particularly come to a head in the public schools because so many of the cases have come up in that context. So there was a whole series of cases where parents challenged sex ed curriculum and other things like that that violated their faith. And the courts habitually deferred to the schools and said they could require kids to go through these things. That's led to, and often they do fix this through legislation, but that led to a lot of legislation in the states to give parents opt out to sex ed curriculum. But you just had this sort of patchwork of protections that was happening across the country when it came to parental rights.
Huh. That's really interesting. And also makes a lot more sense. It explains why we see different things. And is it fair to say, just as a quick summary, is it fair to say that the goal is there more of a tendency or desire to try not to be too prescriptive in order to allow more freedom in America? Could that be like a super layman's version of why they wouldn't necessarily put such a strict rubric in place?
My guess is they couldn't decide on the rubric, but that's
also possible. Yeah.
That's a much better view of, and often that is with the court. They're a little bit hands off in allowing more freedom to decide in new situations and providing more guidance when they think the courts really need it. And so when you see in other areas of case law, this sort of patchwork coming together and protections not being the same state to state or court to court, that's when you start to see the court step in and take more action, which is what we've seen in the last 2 years.
Yeah, and boy, we have seen some interesting ones, which one of our next case is just very recently, and it's Mahmoud v. Taylor, which Moms for Liberty's own people were involved in. So can you explain to our viewers what the core constitutional principle was being debated and what was affirmed in Mahmoud?
Yeah. This has been the most exciting case in my life, I think, over the whole time I've been working on parental rights. But this is a case where exactly what we were talking about, the courts decided to step in and give more guidance on what's going on in the public schools. The case developed out of Montgomery County, Maryland, over curriculum in the school, curriculum that was focused on LGBT issues all the way down to the kindergarten. So there were particular books that were being read that promoted same-sex marriage, different gender ideologies, the idea that you could be born in the wrong body and everything sort of associated with that. And these books were being read all the way down to kindergarten. So a group of parents from many different faith backgrounds came together, and first they tried to opt out of these books and were told they could, and then they couldn't. And they did not want their kids to go through these particular storybooks and the lessons associated with them, because those very lessons talked about the purpose of these books was to teach these kids to internalize these ideas about marriage and about gender and about the world. And they were directly opposed to the religious beliefs of all of these parents, even though they came from many different faith backgrounds. And so they filed a case. It went all the way up to the U.S. Supreme Court, which means they lost at the two levels below, where those two levels sided with the district that this was curriculum, the district could do this. The U.S. Supreme Court took the case, and a landmark decision in this case saying that it's the parents' right to get notice of this kind of curriculum and to be able to pull their child from that curriculum, and that the school needs to respect the parents' rights to opt their children out of things that violate their religious convictions, and particularly the way they want to raise their children.
Did Yoder come up in this one?
It did a little, yeah. It resurrected Yoder and really talked about how that idea that because it was also a case very much about the religion of these parents, more than it was truly a parental rights discussion in the case. But like Yoder, it was talking about how as part of the exercise of these parents' faith, they need to be able to raise their kids according to their religious beliefs, and that they have rights over the religious upbringing of their kids that include having notice of direction from the school that's going to violate those core convictions and the way they want to raise their kids, and the ability to opt their child out of it. So those kids are not being told to internalize and believe things at school that violate their parents' religious upbringing of their kids.
I remember when this was decided, and it was absolutely incredible. It also felt like after it felt like getting a drink of water after walking through the desert for 4 years is really truly what maybe the best way I can describe it. So, however, I did see a lot of pushback online, unsurprisingly, in the Twitterverse. And one of the big arguments that keyboard warriors love to throw out was this idea that, oh, well, they objected to, gosh, all sorts of things. They objected to Trump being the president, so they were going to opt their children out of history classes that taught Trump as a president. I mean, just ridiculous things, which sound facetiously unbelievable. However, unfortunately, today I could actually see someone try to do that. Nevertheless, it's very clear that what that issue comes down, or the issue that will be at the core of that argument, is that I'm just going to opt out, whatever I disagree with. So someone could argue that that's not really going to be manageable for a school if all of a sudden every topic is potentially disputed topic is now optional. So how is that going to be managed? How do we, is it true? Could kids just be opted out of basically anything? Or is there more of a test put to it? Is there more structure put around it?
The structure put around it in the case sounded in the idea of freedom of religion. So it was really centered on the parents being able to articulate that the particular curriculum that was being taught violated their beliefs and the way they wanted to raise their kid in their faith. So it was very tied in directly to that particular issue. And so that's what moves forward from that case, is the idea that at least for parents that have religious objections to what's going on in school, that those objections can be heard, and that the school needs to work with that parent to try to alleviate the burden on their religious exercise in what's being taught at school. But there's still an understanding that schools, by and large, set curriculum and that students are expected to go through it. And I do think that all of these cases leave questions unanswered. So some of the litigation we're seeing come out of the Mahmoud case centers on how do you balance those rights? How many opt-outs are too many opt-outs? And how does the notice get sufficient? And what do you do with other policies that aren't curriculum? And so all of that kind of work is being discussed, I think, in the cases that are coming up through the courts. And I suspect that the Supreme Court is going to have to rule again on some of these issues to bring even more clarity. But it did bring clarity that it really broke open the doors to the schoolhouse gate. And there had been cases before that said exactly that. Parents get to choose public school, private school, or homeschooling. And when they choose public school, they lose their rights at the schoolhouse gate. Mahmoud really opened those gates and said that parents still are the ones who control their kids' education through their free exercise rights within the public schools.
Do you have time to cover one more case real quick?
Absolutely.
Okay, so this one I think is so connected to Mahmoud, it really feels like it. And that's moving into what was just earlier this year in Mirabelli v. Bonta, and brought to a head all of the gender ideology and hidden transition, the secrecy policies that we really have seen nationwide, that I firmly believe that most parents and most people in the country do not realize that schools, many school districts in the nation, have actually explicit policies to hide a gender transition of a child from the parents. I in my heart of hearts, I believe that, because I just don't think there's enough really truly evil people in the world. But that is neither here nor there. The point being, so Mirabelli was incredible, and it was incredible for a number of reasons. So real quick, do a quick recap of what it is, what was decided, but then also, was it an emergency ruling? Is that what it was called?
Yeah, so it came up on an emergency docket. Yeah, so it came up on an emergency docket, which means the Supreme Court decided to take it on sort of this emergency basis without a full court case with full briefing at the U.S. Supreme Court, an oral argument at the Supreme Court. It sort of took it up on this sort of side procedure that it had. And I think the court did that because it was such a critical issue. It had in front of it over and over received petitions to hear cases on this topic. Because you're right, there are so many school districts across the country that have policies that if a student asks to go by a preferred name or pronoun, they will transition that kid at school without telling their parents. They won't get parent permission. They won't tell them after they've changed the names and pronouns, and they will even hide it. We have 2 cases still pending, and we've had more before it, where the school hid the information from parents actively by lying to the parents' faces, to changing school records to make sure that everything that went home had the legal name and female pronouns while they were using male name and male pronouns at school. And these are kids one of our kids was going through an IEP process. So the school was in constant communication with the parents about the academic and other mental health concerns they were seeing with the kid and hiding this information. So these are very dangerous policies that violate parental rights and really hurt kids. And one of those policies was challenged in California in the Mirabelli case. And went all the way up to the US Supreme Court on this emergency basis. And the Supreme Court picked up what it had said in Mahmoud and applied it to this context, making very clear that Mahmoud applies beyond curriculum. It applies to other policies that the school engages in that violate parents' core convictions. It also extended it to non-religious parents. It's sort of a 1 to 2 lines in the decision. It talked about how doing what the school was doing violated the parents' religious beliefs, but then added on that it also violates the rights of non-religious parents. And so it also sounds in this fundamental rights 14th Amendment part of the Constitution, which is important because parents shouldn't just have rights if they're religious. All parents should have rights to make sure that the school is not lying to them and not undermining the way that they want to raise their kids. And so that really signaled that the court's ready to go there in extending those principles to parents, religious and non-religious, because it's so important.
That's so interesting that I had missed that of the non-religious parents. I remember I like deep dove into this case to do just a little bit of a coverage thing for Moms for Liberty, and it was fascinating to me to read the opinions and the all of the documents that went into the court and the background and history. Just it was amazing. But I didn't somehow manage to miss the non-religious parents part, which I think
it was very short.
Oh, okay, good. then there was a lot of reading, so that makes sense. I think that's really interesting because then it sounds like we're removing the concept of allowing or affirming sex rejecting, which is a term I've heard that I think is a lot more realistic, mentalities, it as something that's not just religious, that there is more to it, which I think is really encouraging.
Yes. And I think we'll see the court need to address this issue in a future case, really making sure that these are rights, that parents direct their kids' education upbringing, that this applies in this circumstance, both to religious and non-religious parents.
Well, I so appreciate you talking about these because sometimes I feel like it's amazing how much, again, like I said earlier, has been protected and decided in these battles won. And we just don't even realize that there was a battle sometimes. I think because nowadays it just feels like, well, of course, it's common sense. Of course, today we're living in the age without common sense is how it feels. Do you have a minute if you want to, as we close out, just highlight some of the cases that you're currently dealing with? Because there's a number of cases that are being reviewed by the Supreme Court now, right, in this session?
Yeah, and we had one that the court didn't take on this issue that we were just talking about. It would have been the case following Mirabelli. The court in dissent actually talked about our case, the Foote case, that we did with some allied attorneys, another group that we work with. But this issue of secret social transition is significant, and we still have several cases working their way up through the courts. One that was just heard at the Second Circuit Court of Appeals on this issue. We've got to stop schools from trying to socially transition kids and lying to parents about it. We need to extend Mahmoud to these kinds of other policies. We also have a case in Colorado where it dealt with overnight policies and how a school had roomed a 5th grade girl in the same bed as a 5th grade boy on an overnight trip to DC, and did the same to a 6th grade boy in a cabin on a school-sponsored outdoor lab trip, and maintains that they'll continue to do this to kids after years of litigation. That was just heard at the 10th Circuit Court of Appeals, and is an opportunity for these courts of appeals to apply Mahmoud and Mirabelli in the context of other school policies where parents object to what's going on with their kids, and the school has an easy way to fix this issue. Involve the parents, room students with students of the same sex when you know that that's a concern to them. This can be good for all students to have this information, but we need the courts to weigh in on this issue and ensure protection. We've also been doing a wave of education along with Moms for Liberty to try to help parents understand their rights following Mahmoud and Mirabelli. So I know Moms for Liberty has opt-out resources. We do as well. And I know there's a lot of other organizations that have great resources, but we really are trying to help parents understand how to ask for information and an opt-out and to make sure they do it, because it's just so important. And we'll be doing more work in the curriculum space moving forward, I think, and trying to expand educational freedom both within the public schools and outside of them, as we see parents just really take the reins again in directing their kids' education and upbringing.
Well, that I find incredibly encouraging. So on that note of hope, why don't you tell everyone where they can find, if they have a concern, what is a way that they could contact your organization?
We have a website, adflegal.org, and that is the best place to find out information about our pending cases, things that we're looking to work on, resources that we have available through our parental rights tab on that website. And then we also have a legal intake tab where people can either call ADF or contact us through our website if they have any kind of question or need. And I would encourage anyone listening to this that if you're running into issues in your public schools, please feel free to contact us. We would love to help provide you with information, help you however you need. This is an important issue. It's taken all of us working together to make a difference for the good of kids.
That's it right there. It takes all of us working together, because then it makes this battle so much more manageable, for sure. Well, thank you so much for joining us today. I really appreciate your insights and your expertise, and good luck as the fight continues.
Thank you very much.
We said it today, and it really is true that in the modern world, it's just so easy to take for granted the rights and liberties we have now because of the fight that our fathers and forefathers were willing to take on, whether in the battlefield or in the courtroom. These are just a few of the cases in American legal history that support and protect parental rights. Boy, am I thankful for them, all of them. Because of these cases and others, I can raise my kids as my kids, and you can raise your kids as yours. And what a blessing that is. If you enjoyed this episode, please hit like and subscribe, and then share it with another mom or dad who needs to know the wonderful rights and responsibilities that we have as parents. Because as James Madison said, the advancement and diffusion of knowledge is the only true guardian of liberty. And that's the mission of M4L Academy. Class dismissed.